next part is on the employment agreements and new tool kits.
Alors dans cette table ronde,
Right, now we have another panel discussion. Before we start, we'll be talking mainly about telework. Before we do that, let's come back to this so-called toolbox. We didn't choose the word per chance, and before we talk about telework, we'll talk about the toolbox, as I said. Now, Eva and Anne, I think we heard some type of outcry, people saying, okay, the Macron orders, that's the end of open-ended contracts. Is that not going too far? Absolutely. Now, these are what we call in France precarious jobs. There's an order, 1387 order, which opens up opportunities to the different industries. These are industry-wide agreements, not the social partners in the companies. The law itself will not really change that much. It's an opening towards a wider industry. If we take the example of short-term contracts, the legal provisions that we have at present will not really be changing very much. We'll have the same appeals that have been described by the law, and with all the possible exemptions. Yet, the wider industry will be able to reuse those systems for some cases. For instance, maximum duration of a short-term contract. Now, at present we have 18 months, and it could be extended to much more than 18 months. As we speak, we don't really know much about what's going to happen industry-wide. The trade unions have not really said anything about what they want to negotiate. It's the same also that we could say about the number of renewals for one short-term contract. We're thinking about catering or the construction industry that could have special systems. The only new novelty in the order is the fact that there will be no sanction if the short-term contract is not transmitted or renewed within a time limit of 2 days. For construction sites and short-term contracts, what's important is the legal recognition of a former contract that existed before that was only purely conventional or based on case law. Here again, this Macron order is opening up doors. The different industries will be able to negotiate to set the conditions within which we could sign a short-term contract, but this would be, of course, connected to a construction site or a given operation. So here again, a very interesting tool for the wider industry, but there's not much. In the order as well, what we'll be able to do is to sign a contract in businesses where these contracts are usually used. Now, what do we mean by the usual contract or the usual use of a contract? Well, it'll be for the same industries, that is, buildings, construction of buildings, property development, and similar industries. But it could broaden the scope to other industries. Some industries will do this. They'll use the tool. We were thinking about chemicals companies and other industries such as fashion. We were thinking about Syntec. Do they have a contract as we speak? Well, this will be debated, but it's a wonderful opportunity. Inasmuch as this is a special contract, it's neither a short-term contract nor an open-ended one. It really very much is connected to a given job. When the job is done, people can be made redundant. People will be made redundant within the normal conditions, and contrarily to a short-term contract, there will be no precarious benefits for precarious jobs. So this is not a revolution. Some practices will be better framed, but it's a nice tool. Absolutely. Yet we have other types of agreements called accord emploi, employment agreements. Isn't it where it's perhaps more tricky? correct. These accords emploi is a tool thanks to which we can modify the clauses of the labor agreement. We knew these agreements. We had other agreements to reduce the working time, etc. All of these systems will now be unified and merged. We have one merged, simple system, which will be good for us. What's the objective of these accords emploi? We'll be able to modify the labor contract in terms of total working duration, but also remuneration. Well, of course, as long as you don't go below the minimum wage, and also change mobility. These are majority agreements. What we mean by a majority agreement is an agreement that's been signed with trade unions that have at least 50% of the votes, and the content is very much going to be a bespoke content that is yours, customized. And there's one prerequisite, we'll see if this changes, and the preamble explains how the agreement will be necessary to the functioning of the company or to preserve the development of jobs, which is a bit of a redundancy, we think. But anyway, what we think is that since the social partners, that is the trade unions that have 50% of the votes, have accepted the fact that this is necessary, we think that if it goes to the courts, the judges will not say the contrary. They will not challenge this. Now, when the agreement's been signed, it will be valid for 5 years. This is common law that applies. There's nothing else we can do. And when the agreement's been accepted, it'll change the clauses in the labor contract, in the work contract, that would be incompatible. Now, is this to replace the old system, or is it a modification? Now, if we have a short-term contract, it's not the case, but those who are against say it's a modification. That is, there's no going backwards. That is, that'll be a change to stay in the labour contract. The employees have a month's notice to say no in writing. If they don't say no in writing, it means that those who keep quiet will accept. And if they refuse, the employers have 2 months to start the redundancy procedure, to trigger the redundancy. And this would be for personal reasons, on personal grounds. And the real and serious cause will be presumed or supposed. That is, if the employees say they do not accept their redundancies, then the judges would just have to check if the individual procedure's been complied with or not. So 2 months to trigger the procedure, as I said before. There's no special systems on this. That is, no redeployment. There's only something for the training of employees. There's an employer contribution in the training schemes that will be upped. But we don't have a decree at present. Does that mean that we have to slow down in these accords emploi? No, it seems no. We can start negotiations, but this is a bit theoretical. We're waiting for the law to be finalized at the end of December. I think we'll know more about these amendments. But we've understood the gist of it. As you said, people can interpret the content, the substance of things, so there might be all types of impacts. At the end of the day, the only locking system in the agreement is that it has to be signed by the majority. It's the group that's going to lock the whole system, but it's a nice tool for a company to be more competitive if they can negotiate the agreement. Okay, that's the more or less introduction. So marginal changes, good tools, and interesting potential. Well, we'll see if this is the case or not in the foreseeable future, in the months to come. Now, what we'll be discussing is telework. Now, everybody's convinced that this is not the latest fad any longer. It's for companies to keep talented workers. OECD reports have shown that only 15 to 20% of employees in France are concerned by telework, which is a percentage which is a lot lower than in the UK or the northern part of Europe. With the Macron orders, will speed up, and there's going to be more telework. Telework will be organized not as a rider or additional clause, but within the labour contract side. The objective is, have we met our objective? With these orders, will we have more teleworkers? is it going to be facilitated? I wouldn't have used the expression facilitated. I would have said, we're just going to recognize that more and more people today work at home. They do this either in a one-off fashion or when they're roaming or moving around. As the 1-point HR director was saying before, in the past, work was either working on a constant basis at home, and for this you had an additional clause or a rider, or people were not doing this officially. Now, all types of variants are recognized as telework, and also will recognize the status of the teleworker. For instance, in terms of vocational accidents, if they have an accident where they work. So far, this was a bit challenged. Will deployment of such a system be facilitated? Well, we don't really know, because in the past we could have had an agreement for teleworkers, but it was rarely done. It was either in a contract or in a rider. But now with the new Macron orders, what we must do is organize telework with a company-based agreement, in the way Jérôme's described. So what will be very important will be negotiation. That'll be step number 1. If there's no company agreement, then a charter will have to be signed off and will have to be sent to the CSE. As far as the content or substance of the charter is concerned, we have a number of elements from the Labour Code. For instance, the charter will have to explain the conditions, the working conditions for the teleworkers, the moments when the teleworkers have the right or must work. If the company doesn't want to organize this regularly and to have regular teleworkers, if they don't want to have an agreement or a charter, they can do this on a one-off basis. And according to the new order, this can be done in any way you want. That is, you can just exchange a few emails with your workers, and that'll suffice. This is what we thought several days ago when we only had the orders. That's true. There's a bit of a novelty in the ratification law. In this draft, the scope will be extended. That is, companies will be able to use teleworkers in the way they want, and this applies to all usual telework forms. Now, in this article, they're saying that's the case if there's no charter, if there's no company agreement. But then we thought, what's the point for some companies? Why should they do this? Well, maybe if the agreement has failed, then they could consider a charter. Why would they want to have this grey type of telework? Of course, it gives them flexibility, but it's not well organized in this case. That's true. What's surprising is that this amendment, according to Mr. Petrawiecki's report, this amendment had one single objective, which was to give more rights to teleworkers.
So the idea would be to enable all employees to request to apply for telework. But at the other end, this possibility to remain in that grey area, is it not running contrary to the spirit of the law? It's going to be a very hazy situation with a lot of legal uncertainty. And of course, a charter or no charter would be required, no agreement would be required. I've decided that we'd stay home and work from home today. Is that okay with you? Or perhaps next week, I won't be available. I'm going to be working 2 days in a week. The manager says, I don't have any problem with this because we have an agreement. So how are they going to go about implementing the conditions for this system? So far we don't know. Jean, is it what you have observed? This particular amendment goes against or challenges the progress of this reform. It's not a giant step taken forward. It would be a minor step forward. Well, this is what we are going through. I very much enjoyed what Jacques was saying. Now we live in a massive digital transformation situation. There's no going back. It's what competitiveness implies. We are a Latin country, so we like to lag behind. You've seen the Macron orders were perceived as a way to stimulate, even if it's a symbolical stimulus. So I'm kind of torn between the agreement, which is a positive one, as it suggests the setting up of a framework okay, beyond the fact that you will have the right to work from home, you have to organize the framework. It's not just a tolerance. Very often in France, working telework is synonymous with the working from home. It's not the fact. You have many people who are considered as being nomad Romans, and they can actually work from anywhere. With Loi Warsman, and this one clearly, when a change occurs in the law, then companies decided to take their fate in their hands and get organized. And giving more flexibility with casual teleworking, possibly this is a plus. Because, frameworks are a hindrance. It's too complicated, it's too cumbersome. So I'm kind of torn. However, I do prefer having a framework to work in, because when it comes to large groups, this is the best way to organize teleworking. I think it's important to have a framework. Eva, would you say that the relevance or the point of the charter is to make it become a strategic point for the company, and therefore everything, the whole organization, the group, will turn on it? I share Jean's view. We're a Latin country, so okay, let's not change, let's not regulate. Now, the charter or the agreement is an opportunity for the company to use the new mode of organization to really leverage it and to actually use it. We know it can attract talents. It's perceived in a very positive way. It sends a positive message. A number of studies have shown that the time that you save by working or teleworking, 50% of this go back to the company. So it's attractive and it's highly competitive. And the charter, the agreement, is the best way to set the rules of telework. It should be casual teleworking, working from home exclusively. Could it be co-working? Is it allowed to be taking place in a secondary residence or just in the main residence? How about the time slots dedicated to teleworking? If it's a given time in the day, of course, it makes it more difficult to fight this presumption. How can you reconcile these time slots with people who are independent? What about the right to disconnect? You have to have a gateway. If you're at home, potentially you're always connected. Now, there is this thing called the right to be disconnected. So the charter is a good opportunity to tackle this problem and the question of costs too. The article of the bearing, of course, has been repealed. We know it's a general obligation to cover professional expenditure. There are a number of obsolete features. For instance, on the internet connection, most employees have a connection. So if they want to telework, if it's accepted, there won't be any additional cost. So it's good because it helps you take on board all these issues, make sure that you know how to manage this, and perhaps you could also start with an early diagnosis to clearly define the positions and the task. Now, there are positions, there are jobs and tasks, and not all of them are available or feasible in teleworking. And then I'm very much a jurist there. The charter per se is not opposable. So perhaps you need to append it to the bylaws so that it doesn't is endowed by a legal force. We are Latins. Charter, a list is good. It's useful, and being jurist, we appreciate this legal framework. But at the same time, if there is a framework, it means or it implies that you can't get away from the framework. So, is there not a risk of freezing the applications of the jobs that can apply? Because there is such a thing as the right of refusal on the part of the employer, provider he has legitimate motives. And this again is a new feature. If the employee is eligible to that position as defined in the charter and the agreement, and then let's not forget that charter implies a prior consultation of the CSE. If you have an agreement, of course, it has to be a company agreement, so therefore there will have to be negotiation. So if there is a charter And of course, certainly there'll be discussions at the CSE with the elected officers. In other words, you're not free to do exactly what you want to do. Or if you go that way, be careful, as there is a risk of freezing something which by nature is extremely flexible. You're freezing this, and the question of eligibility is a key one. Why is it that you need to motivate, to give the reasons for your refusal? You're not allowed to work from home today or telework today. Well, typically the amendments shows that it is a right. So what about eligibility as opposed to the fact that you're not supposed to say no? If it's a right, Mr. Bensi said you have to, there has to be a right to telework. So we had a discussions on this point. Right is rather an entitlement than actual right. The legal framework leaves the possibility to companies and social partners. It's an open possibility. It's more an entitlement than an actual right. So when the employer has a listed number of jobs or positions that are eligible, they can only refuse the stride to a eligible position if it gives a reason for that. What do you mean by the reason? Giving the reasons, I suppose it means objective reasons, those which are bound to be challenged. Of course, there's bound to be a proliferation of litigation and bits and pieces of case law that eventually would tell us what we mean by a lawful reason. For instance, your apartment is too small, you can't work from home. You have too many children that keep you busy, and you can't really work properly in such a busy environment. So what about the objective elements? And then another question. Outside of a charter of an agreement, no division of eligible position, can you refuse the right of access to telework for an employee? Does it mean that you can refuse, say no at all times, or does it mean that you can never say no? Both are possible. So again, what do you mean by legitimate reasons? On the one side, the right of access or the entitlement of the employees is easier because it's more legitimate. If he can request it to apply at any place at any time. And then as the case law becomes more abundant, the reasons will become more and more important and more legitimate, and therefore eventually the employee will be allowed or entitled to request the possibility to work from home or to telework. Perhaps we should have argued on other grounds rather than starting with the definition of number of positions according to the workstations of the position, doing it on the basis of a task. For instance, maybe 20% or 40% of your tasks will be performed from at a distance rather than from your office. Don't you think that would be the more reasonable approach? Probably yes. Sometimes, one makes a mistake. Our center came up with a list of the positions. When it comes to digitization, you start with a task, and going up, you end up at the company level. My spouse, my wife, is a speech therapist. She sees patients, and then she proposes examinations, and she writes reports, and she writes reports from home. Now, in fact, 40% of these reports are drafted at home, even though it doesn't appear to be the case. It's for each company, they're all different. Each individual is different. Some people don't want to work from home. Some need to have a team around them. And then the question of management. So going back in the right direction, starting at the basis, at the beginning with the tasks, looking at the specific features of companies. All of them have their features, and they don't want to have an atomization, a fragmentation of the work. Those that have gone too far, like HP, Yahoo, and similar, decided to go back. So it's a question of finding the right balance. you referred to the sites. For many people, at least in France, working from home is synonymous with the telework. It shouldn't be the case. 90% of people do telework from their workstations at the office. It's working at a distance. That's what teleworking is all about. And many people who are at work in their daily day-to-day activity, like this morning, I worked on the train. Then I'll be taking another train to go back to Lyon. So I'll be traveling a lot, and that's what I mean by teleworking, working from my traveling place, as it implies risks, the rise to disconnect. If it's an endless ride, you're bound to end up with burnout situations, people who will never stop working. So far, telework was based on the voluntary basis. You can impose this either to the employer and employer. It was reversible. You would test the ground, test the water, say, I don't like it, and go back to your usual pattern. People in telework, very interesting in the Greater Paris. Some people who come from not far away and spend 3 hours traveling, not acceptable. If it's reversible, so they would overinvest and tell the boss, you see, telework, you were right to grant it to me. But then, trade unions were caught, of course, teamwork is getting very difficult. And that's the main problem for trade unions. They don't like this. If I understood correctly, these agreements would apply to the private in the sector, not the public sector. I've worked with many municipalities and local bodies, and telework is very useful. That it gives them a lever on the price of real estate. And again, there's an issue there. My last point, it's a highly cultural, a pillar of a cultural in France. Many managers tell me, okay, I'm ready to try this, and that's when they cut down the long list of eligible persons, not to end up with too many people, because they don't want to working and want to be too fragmented. We like to be equal and to be fair in France. So you can tell someone, okay, it's a big plus because you're not costing that much in terms of commuting and traveling. 30 seconds to tackle the last point. You said if the word with the employer, if he says no. Suppose I'm the employee, I work in telework basis. Suppose I don't feel like complying with the outcome of the charter after negotiation. Okay, we have a common agreement, you have a charter, and then you have people who are already in telework. It's based in their agreement, in the amendments. Now, the clauses or the provisions of the charter or the agreement will eventually replace the clauses of any contract. For instance, your time slot. You were accessible from 12 to 2 p.m. The charter said it has to be 10 to 16. So this will be replaced. Now the employee may say no, is given a 1 month time to say no. Otherwise, silence is consent. What it doesn't spell out the consequence of his say no. Suppose the worker wants to continue working from 12 to 2 or to 4. It seems that the contract's clauses will remain untouched, will remain valid. Now, in order to loop the loop, you can go even further and say that a telework agreement might be part of an employment agreement because it's required for the proper operating of the company. And this, otherwise, if he says no, he might eventually be dismissed. So you've actually looped the loop. By way of a conclusion, a few seconds for the conclusion. Yes, does it actually make businesses and companies more attractive? Yes, but we have our doubts as to the concrete implementation of the system. Now, to go back to what Mr. Humbert said, it restores some balance in favor of a group working or group power. Companies will have to be ready and willing to negotiate. And it's going back to square one or to the origins, because sometimes, employees were not doing their side of the bargain. So here it's giving the opportunity the group to make companies more attractive. It's a way to attract talents, as these new modes of telework are bound to be more flexible and therefore perhaps more attractive. Thank you very much for sharing your experience with us.